Good day everyone, my name is Jerson Albidonia and I'm about to report the Article 8 Judicial Department from Section 13 to Section 16. So first, let's define the meaning of the Supreme Court of the Philippines. If natakol na ni siya sa ubang reporter, maybe recap na lang siguro ni, no? So the Supreme Court of the Philippines, or in Filipino, kataas-taasang hukuman ng Pilipinas or Korte Suprema, is the Philippines' highest judicial court, as well as the court of last resort. The court consists of 14 associate justices and 1 chief justice. Pursuant to the Constitution, the Supreme Court has administrative supervision over all courts and the personnel thereof. So, ang Supreme Court no is mo gid ni ang kuan pinaka-highest nga korte diri sa Pilipinas, a judicial court sa Philippines. And nag-consist ni siya og kanang 14 associate justices and 1 chief justice. So, but anyways, let us move forward na lang sa kuan sa section 13, which is akong topic. So section 13. The conclusion of the Supreme Court in any case submitted to it for decision en banc or in division shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification to this effect, signed by the Chief Justice, shall be issued and a copy thereof attached to the record of the case and served upon the parties. Any member who took no part, or dissented, or abstained from a decision or resolution must state the reason therefor. The same requirements shall be observed by all lower collegiate courts. So, meaning, ang kuan, under this section 13 no is, mao ni siya ang kanang kuan bitaw. Ang pagpasya sa korte, ang pagpasya sa Supreme Court sa unsa man na case na iharap para desisyonan sa en banc or in division is dapat ma-reach in consultation daw before ang kaso ma-assign sa usa ka member alang sa pagsulat sa opinion sa korte. So ngano iagi pa man una ang conclusion sa decision in banc or sa in division this ma-appoint sa korte. So unsa dining in banc decision di ay? So based on my research, ang in banc is from the gikan siya sa kuan sa French word which is kuan in the bench, meaning it signifies a decision by the full court of all the appeals judges in jurisdiction where there is more than 3 or 4 judge panel. More than 1 daw. Medyo kung siguro 3 or 4 judge panel. But generally speaking, when the circuit court hears an argument, they will assign a 3-judge panel. And oftentimes, after the decision is rendered in that matter, sometimes parties will essentially go ask for hearing en banc, which means that the entire circuit court will sit and hear the argument to determine whether or not the 3-judge panel ruled correctly or not. Sa quorum of Supreme Court is sa quorum of Supreme Court naman is ang tanan judges sa en banc must form as one. Dapat mag-unite gini sila no sa kuan, dapat magkaisa gyud ilang decision ani sa pag-vote sa kaso. However, naka-indicate po diri ang in division. Kanang in division no. Dili ni siya matawag na in banc kay dili sila as one or wala sila nagkaisa sa pag-vote sa kaso, pero kailangan gihapon ang majority vote nila sa isa ka kaso. Kung hatulan ba ang defendant na guilty ba na or dili. Basically, ang required number of votes ani is 9, then minimum yata ang 5. Amot lang mo pa na akong pag-search, but ang also and kuan pod also ang isa ka certificate to this effect nga gipirmahan sa Chief Justice is gikinahanglang nga i-issue og usa og ka-copy, dapat na isa ka copy na i-attach sa record sa kaso ug gihatag sa partido. And if naay member nga wala ni appeal or ni supak or nag-abstain sa isa ka decision or sa resolution, dapat dapat mag-state siya kuan reason nganong nag-abstain siya, nganong wala siya ni appeal sa or nganong nisupak siya sa decision sa resolution. The same po ang buhaton sa kuan sa mga naas lower collegiate courts. The same ilang buhaton nga kuan dapat mag-follow. The same ang ilang i-follow nga patakaran nga kuan nga dapat ilang sundon. So let's move forward to section 14. Section 14. No decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. No petition for review or motion for reconsideration of a decision of the court shall be refused due course or denied without stating the legal basis therefor. So decision. Decision is a judgment rendered by a court of justice or other competent tribunal after the presentation of the respective positions of the parties in an ordinary or criminal case of upon a stipulation of facts upon which the disposition of the case is based. So what does the rule on decisions and petitions require? So the court clarified the constitutional requirement that a decision must express clearly and distinctly the facts and law on which it is based as referring only to decisions. Actually, naatay gitawag na memorandum decision na after a careful and thorough perusal, evaluation and study of the records of the case, and ang kaning memorandum decision is mao ni ang judgment or ang final resolution sa korte in appealed cases that may adopt by reference the findings of fact and conclusion of law contained in the decision or final order appealed from. Lang ni siya, kaning memorandum decision is kana siyang written document sa korte that only gives the result of the court's decision on a case. And usually, lang ni siya, very short and does not include the court's reasoning or explanation for reaching the result. Ang purpose man jud ani na requirement is to inform the person reading the decision and especially the parties of how it was reached by the court after a consideration of the pertinent facts and examination of the applicable laws. So mato siya. Dapat magkuan lang gyapon, mag-rely lang gyapon sa facts, no? Example ana nga facts is kuan or ang example ana nga kanang nga reference sa pagpangitag makatotohanan ng mga kuan is ang kanang evidence o kana siya. So in section 15, 1. All cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission for the Supreme Court, and unless reduced by the Supreme Court, 12 months for all lower collegiate courts and 3 months for all other lower courts. 2. A case or matter shall be deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of court or by the court itself. 3. Upon the expiration of the corresponding period, a certification to this effect signed by the Chief Justice or the presiding judge shall forthwith be issued and a copy thereof attached to the record of the case or matter, and served upon the parties. The certification shall state why a decision or resolution has not been rendered or issued within said period. 4th, despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matter submitted thereto for determination without further delay. So, delay. So, sa section 15, under diri ang court decision, which we call judgment. Pagkahuman sa mga niagi na court proceedings, mauni ang pinaka-final judgment o diri ang basihan para mabaw-an nato kung guilty or dili ang isa ka tao. Kung unsa ipatos na punishment, kung pila siya ka years sa kulungan and etc. In hearing cases naman is tanan na mahimo na decision sa korte is dapat mag-rely ra jud sa clear and distinct na facts like mga evidences na akong giingon gaina para mabaw-an nato kung nakahimo ba jud ang isang kana nga tao labag sa batas bitaw, nga if nakahimo siya butang nga labag sa batas ana day. And also under sa section 15 ang maximum period for rendition of decision. Meaning, pag nahumana ang court proceeding and subject na ang kaso sa court decision, dapat sa sulod dapat within 24 months or 2 years is naana ang decision sa Supreme Court. However, ang Court of Appeals and other collegiate appellate courts is dapat naana pod ang court decision within 12 months or 1 year. Ug pag pag ang lower courts pod dapat naana pod ang court decision within 3 months lang. So ang pangutana nganong naay time limit na kailangan na nga naa na ang desisyon sa nanay desisyon ang korte. Kaya ang time limit na gihatag sa ila is para magdesisyon ug para dili magkapatong-patong o matambakan ang mga kaso ug para mahatag dayon ang karapatan sa tao nga makamit niya ang hustisya as long nga makamit niya ang hustisya sa mabilis na panahon. So pag nalabag ni sa mga korte, pag nalabag ni sa korte ang Article 8 Section 15 kung asa sila wala nakapag desisyon sa kaso within the time limit or period of time na gihatag sa ila is pwede sila mag-ground for impeachment. So remember that. So last, in section 16, the Supreme Court shall within 30 days from the opening of each regular session of the Congress submit to the President and the Congress an annual report on the operations and activities of the judiciary. So in this section, under ani is ang submission of annual report. Meaning, ang Supreme Court is dapat within 30 days gikan sa pag-abot sa kada regular session sa Congress is dapat mag-submit na sila sa President o sa Congress og annual report sa mga operation sa mga operation o activities sa judiciary. So mao to siya. So that's all from Section 13 to Section 16 of Article 8 sa Judicial Department. So thank you for listening. God bless.